It's now my pleasure to introduce Professor Abigail Moncrief. She's the Peter Paul Career Development Professor at Boston University School of Law. She earned her BA cum laude from Wellesley College, after which she took a Fulbright Fellowship to Geneva to study comparative healthcare systems. She earned her JD with honors from the University of Chicago Law School, after which she clerked for the Ninth Circuit before serving as a gubernatorial appointee for the Health Information Technology Council for the state of Massachusetts, and then teaching and serving in her current position. Professor Moncrief focuses her scholarly work on structural government barriers to efficiency in healthcare payments and delivery, as well as writing more broadly on structural constitutional law. So like Professor L. Haig, her interests in writing are actually quite broad in scope. Professor Moncrief has published articles on both federalism and separation of powers, publishing on the major questions exception to Chevron deference and administrative law review. I see all of the law students cringe when they hear that. On healthcare federalism and separation of powers in the Boston University Law Review, and on federalism issues in medical malpractice, and more broadly proposing a concept of federalization snowballs in the Columbia Law Review, for which I know she credits Professor L. Haig's mentorship. So please join me in welcoming Professor Moncrief.
Thank you so much, Sam, and everybody for having me. Just for the record, I grew up in Dallas, so Oklahoma is not so much a flyover state as like a state. But now I'm very happily installed in Massachusetts, so less of the rivalry now. So I wanted to actually, before I get to my own presentation, which probably won't take the full half hour, just say a couple of words in response to Chris's presentation. So one thing that I find really interesting about the split benefit idea is that it's essentially what a lot of car insurance does, right? Like they just give you cash to repair your car if you want to, but in most states you're not required to actually repair your car. And so you can drive around with a ding in your door and take the money as compensation for the reduced value in your car. And we don't think that's a problem. So why is it that there's this instinct to think that it is a problem for healthcare, that consumers are not good enough at deciding whether it's okay with them to walk around with a ding in their door, as it were? And I think that part of the reason is that because so much of healthcare doesn't have an evidence basis, we don't trust ourselves to know what healthcare is good for us or not, because nobody knows what healthcare is good for us or not. And so we don't think that the consumer can make a rational choice between the ding in the door and fixing the ding in the door, because we don't really know how much money it's worth or how much harm it's going to cause to not cure a particular problem, or at least not try to cure a particular problem that we're having in the medical context. And so I think it's an interesting idea to say, well, why don't we just give the consumer cash and let the consumer decide? But you have to have a fairly strong libertarian prior to think that that's a good model for healthcare, and to think that, well, that consumer, if he or she makes the wrong choice and ends up going from having a relatively minor healthcare complaint to having a really big healthcare problem because we didn't nip it in the bud because we were not sure whether or not we needed to, then that's okay, and we're just going to have to maybe let that person, well, if we don't want to escalate healthcare costs because of that, we might end up needing to let that person go without healthcare down the road too. I think there's more complexity there than Chris's paper indicates, but I do think that it's a really fascinating idea to sort of play around with, and I look forward to reading the responses to objections in the Symposium piece. It's also a bit related to what I want to say here, although the PowerPoint doesn't deal with the part of what I'm going to say that relates to Chris's thing. So maybe I'll just tack on at the end if I have time. So Einer's most recent book was this incredibly impressive, very quickly put together series of articles that he had written for The Atlantic and National Review Online and various other sort of more popular online sources, of arguments in favor of the constitutionality of the individual mandate, which, by the way, Einer opposed as a matter of policy. But as a matter of constitutional law, he thought was totally fine. So he writes this series of articles and combines them together into a book, making a originalist defense of the individual mandate. And by the way, Einer's also not so much an originalist in most of his constitutional thinking, I don't think, right? Maybe a little bit? Okay. I don't think he was an originalist, but I suppose that. Okay. So he writes this originalist defense of the individual mandate and puts it all together in a book. And here's the originalist research that he put together. So he says, he goes into the history from the late 18th and early 19th centuries and says, look, in 1790s and 1800s, we had purchase mandates. We had mandates for individual purchases of medical insurance and hospitalization benefits for seamen. Medical insurance benefits were required to be paid for by vessel owners, and hospital benefits the individual seamen themselves had to purchase. There was also a requirement that all able-bodied men buy and own guns. Amendment on steroids. Federally required. And Einer says this history demonstrates that the framers thought that individual mandates were, quote-unquote, proper exercises of national power. That's in quotes because it's a significant constitutional term, right? The necessary and proper clause says that the federal government is allowed to pass any kind of law that's necessary or proper to the execution of enumerated federal powers. And Einer says, well, the health insurance mandate helps to regulate commerce in health insurance and in health care. And the only objection to it is that it is improper to force individuals to purchase a product, to enter into a contract. Einer says framers didn't think so. Framers passed these three individual mandates, and so it must be a proper exercise of federal power. The opponents to the individual mandate come back with the following, which was all not very compelling. So they say that these things were passed under the maritime law or the militia power, not under the commerce power. They say that the mandates for medical insurance were enforced through a duty, which was through taxation, not regulation. And they say that the subjects of the prior insurance mandates were already active in commerce because they were seamen. So they had done something actively to put themselves into commerce that they could choose to undo by leaving their jobs. And that the mandates were therefore more limited because they applied to people who were already active. So Einer writes back. The book is fascinating. It's this dialogue between him and his opponents. And he says, maritime law was the commerce power. That's what that was at the time. There was also a separate power to alter common law maritime decisions by the courts, but that wasn't what this health insurance mandate was. It was done under the commerce power. He says that the distinction about whether the seamen had been active in commerce or not doesn't matter because everybody in the United States is active in healthcare commerce at one time or another, and that's directly related to health insurance. So we can say that everybody who's subject to the Obamacare mandate is also active in commerce, the same as the seamen. And if you don't need a connection between the active commercial activity, awesome, between the commercial activity and the mandate, then you can say that everybody subject to the Obamacare mandate also is active in commerce by earning income, because the health insurance mandate in Obamacare doesn't apply to people who don't make income. It's enforced solely through income taxation. So the conclusion of the debate and the conclusion that Einer reaches in response to all of his, at the end of all of this dialogue, he says the individual mandate is not novel, contrary to the opponents of the individual mandate's assertions, and something the framers had no trouble seeing as proper for constitutional purposes, and it is just as related to interstate commerce as the versions from the founding era, as the health insurance mandates from the founding era. And then this sort of stunning admission from Randy Barnett, the intellectual architect of the challenge to Obamacare's constitutionality. And he eventually writes, I never rested the individual insurance mandate was unconstitutional in the original meaning of the Constitution, and neither did the parties to the lawsuit. So Randy Barnett, this scholar who put together the challenge to the individual mandate, and who also wrote a scathing critique of Scalia for being not sufficiently originalist, says, I wasn't being originalist in this particular argument. That wasn't ever my point. So Einer manages to draw out this big admission from Barnett, and it looks like Einer's got the better end of originalism on this particular argument. So then Obamacare goes to trial, and what happens? The government's lawyers, including the Solicitor General, Donald Verrilli, just didn't make this argument. They just didn't present it. They didn't talk about the founding era mandates. Then the conservative justices, including the self-proclaimed originalists Justices Scalia and Thomas, held that the mandate is unconstitutional. It's not a constitutional exercise of the commerce power, in part because it's novel and not proper. And Chief Justice Roberts' opinion rests its Commerce Clause analysis on inactivity of the mandate subjects, saying they're not active in commerce, you can't force them to be active in commerce in health insurance. But then inconsistently, he says it's constitutional under the taxing power, and as part of his analysis there, he says that it's okay because it's limited in application to those with income, who, as Einer has said, are engaged in commerce. So Einer has this great argument defending the individual mandate on originalist grounds, and nobody picked it up in the Supreme Court, despite the fact that it was easily accessible online and other places. So what happened? So maybe Einer's argument was too distant and discontinuous, meaning that the founding era mandates had been passed and enforced in the 1790s and early 1800s, but then had gone away and hadn't been present in the United States in between the founding era and today. So maybe they didn't count because they were there at the founding era, but it's not like Congress regularly used that power in between. Maybe those mandates were just too narrow because they only applied to ship owners and seamen, and maybe the real objection was this mandate is bad because it applies to basically everybody in the United States. Exceptions for people who make too little money, but there's no way that you can get out of the mandate except by quitting your job and becoming poor and earning less income than the cap, whereas seamen at the founding era could potentially go get a different job that still makes the same amount of money. They don't have to put themselves into poverty in order to escape the health insurance mandate of that time. So maybe you could distinguish it on those grounds. But then there are other hypotheses too that might explain why Einer's argument didn't get picked up. One is maybe just the justices are unprincipled. Maybe they claim to be originalists, but they actually don't care about the original meaning of the Constitution. Maybe they were completely just confused and befuddled by the activity versus inactivity distinction. They just thought, well, these people are not active in the health insurance market, and you have to be active in the health insurance market first before you can have a health insurance mandate applied, and it doesn't matter that they're active somewhere else. Or maybe they think that we're not active elsewhere in commerce because I don't know, making income doesn't count as being active in commerce. Maybe the government lawyers just didn't know about this particular argument and they screwed up by not including it. Maybe we had, in the October term 2012, unusually stupid or rogue clerks for the justices. Maybe Scalia and Thomas really wanted this argument there, but the clerks were like, and didn't put it in. Or maybe there were political constraints on the justices. Maybe the justices couldn't use this argument for some reason because they thought that Americans wouldn't like it. So we'll look at each of the hypotheses and try to decide which one makes the most sense. So the first one, that the original statutes were too distant or discontinuous to count, shouldn't matter to originalists. Originalism, if sincere, doesn't make space for the narrowness, distance, or discontinuity. If Einer is right that these mandates existed at the founding era, that gives us pretty compelling evidence as to the original public meaning of the word proper, which supposedly is what originalists care about, the original public meaning at the time of the founding, and shows that the original thinkers about the Constitution thought that mandating purchases was a proper exercise of federal power. So it shouldn't matter that these statutes are all really old and that Congress hasn't done the same things throughout history. On the second one, that the justices are just unprincipled, Chief Justice Roberts ultimately upheld the mandate, so he at least was not unprincipled. He wasn't just trying to get rid of a statute he didn't like out of, we can't use a pure judicial realism type of argument to say that that's why Einer's argument failed, because Roberts ultimately upheld the mandate and allowed the statute to go forward. And the activity and activity distinction likewise didn't matter to Roberts' taxing analysis, so again, you can't just say that he got completely befuddled by this activity and activity distinction. On the idea that the government lawyers maybe just didn't know about this argument, maybe failed to present it out of weird constraints, I have a good, reliable, off-the-record source telling me that the Solicitor General knew about this argument and did not feel that it was a good argument to present, and so made a choice not to present this particular argument. And he also said, the source also said that he didn't feel politically constrained himself to not present this argument, that wasn't part of his logic, so he just thought that it wasn't going to win. Were there stupid rogue Supreme Court clerks? Probably not. Pretty hard to become a Supreme Court clerk. So then, where does popular constitutionalism come in? The idea that I think is most likely to be the reason that this argument didn't make it to the Supreme Court and didn't make it into the justices' opinions is that current political preference mattered to the Supreme Court justices. So the Solicitor General and his team looked at what they thought, measured what they thought the Supreme Court justices were likely to think was a compelling argument, and they thought, well, this originalist research isn't going to get us anywhere because the Supreme Court justices just can't hold that Congress has the power to mandate purchases of anything under the sun. The Supreme Court of the United States can't be seen to hold that Congress has an unlimited power to mandate purchases, which is essentially what Einer's argument was, that if you look at the original public meaning, purchase mandate is a proper exercise of federal power. What does that imply? Yes, the federal government can mandate purchases of broccoli. It won't, because mandating purchases of broccoli is stupid, and Congress isn't that stupid. It's close, but not that stupid. And so there are political constraints that will matter to Congress too, but ultimately, yeah, Congress has the power to mandate purchases, at least as applied to anybody active in commerce, currently active in commerce, which is anybody making income. So the problem was that the justices didn't want to hold that, because they didn't want to scare us and make us think that they were not, that they were not going to be good guardians of our liberty. So we have good reason to think that that's right? This was a moment in history when the Tea Party was making a lot of noise about limits on congressional power and libertarian constraints on congressional power, trying to push for greater protection of economic liberty, and they were getting some traction, and the polls were showing that a lot of people did not support Obamacare, and in particular were opposed to the individual mandate. Interestingly, this didn't seem to apply to the taxing power, perversely, because the Tea Party types already think the taxing power is expansive and evil. So holding that the taxing power allows the individual mandate is not as risky in terms of ticking people off, and the Tea Party types really upset as holding that Congress has a regulatory power to force individual mandates. So the hypothesis that seems to make the most sense, given what we know, is that the justices were attuned to today's political preferences and were unwilling to hold that Congress had this expansive power to mandate purchases. The surprising part of that, though, the really surprising part of that, is that popular constitutionalism mattered more to the originalist justices more than their professed commitment to originalism. So if there's anything that's the opposite of originalism, it's popular constitutionalism, right? Caring about today's sense of what the Constitution means. So what can we take from that? What can we take from that sort of surprising conclusion that the justices cared about the Tea Party push for or against individual mandates? So one possibility is that popular constitutionalism is just more powerful than most of us give it credit for, that the justices care more than we thought about what we currently think about the meaning of the Constitution. One possibility is that popular constitutionalism itself is not all that powerful, but that other constitutional theories are also not that powerful and are less powerful than popular constitutionalism. So if the justices have a good textual or other kind of doctrinal reason to make a decision one way or the other, maybe that would trump popular constitutionalism, but other sort of theories of like originalism about how the Constitution should be read will take a back seat to a really strong popular constitutionalist movement. One possibility, which I didn't put on here but should have, is that this particular popular constitutionalism movement was just really, really, really powerful. It's the last one. It's right there. Obamacare was just fluky in its degree of unpopularity. People just really, really hated Obamacare. And then one possibility is that originalism is just uniquely weak as a constitutional theory, that it will always take a backseat to something else that could trump it. Justice Scalia has sort of admitted this by calling himself a faint-hearted originalist, but Randy Barnett, who was the one to sort of cave immediately to Einer's research, is the one who wrote this scathing critique of Scalia's infidelity to originalism. So he really has no excuse for dumping on his originalist roots once he saw the unpopularity of Obamacare. So this is just kind of this fascinating examination of what happens when we have really strong political preferences one way or another, and a really strong originalist argument, and we got Einer in dialogue with the justices, with originalists, and the solid originalist argument in favor of the individual mandate just lost. And not only did it lose, I should say, the justices sort of skated around it and pretended that it was wrong without actually rebutting it. They were like, they got up and said, this is a novel exercise of congressional power, despite the fact that it clearly was not. So it was just a really interesting story, and I don't have a solid conclusion about what we can glean from it other than just, this was a weird little case. This was a weird, very big case. And very weird, very big case. And maybe originalism is not as strong of a commitment as one might have thought of the conservative justice on the court.